Hello and welcome to another edition of Questions for Lawyers. I'm your host, Jeff Adelman. I'm a personal injury attorney. And I started this show because even as a PI lawyer, I do get a lot of questions from clients and people looking for legal help that are not in my field. So I have to consult with a lot of experts in the legal community in different areas of law. And today, we're honored to have with us Brian Koch from Greenberg Traurig, who's going to be talking with us about commercial litigation. And since we practiced this a little bit, I think this is going to be a really good intro for you, Brian. I have a feeling.
Absolutely.
Could you please introduce yourself to everyone?
Sure. Hello and good evening. My name is Brian Koch. I'm a shareholder in the Fort Lauderdale office of Greenberg Traurig in the litigation department. As a litigator, I represent companies and individuals involved in business disputes primarily, but they could also be individual disputes depending on the nature of the particular case. As a civil litigator or commercial litigator, the issues are generally fights over money. Either some clients are trying to obtain money from somebody else, for example, a breach of contract, or you have situations.
We can hear.
Great. They can hear. Or we also have situations where we're defending claims. So somebody else may be trying to obtain money, and of course our clients are defending that particular position depending on the nature of the case.
And how long have you been with Greenberg Traurig?
I've been with Greenberg for about 13 years. I've been practicing collectively for about 16 years now. And I've been privileged to work with a couple of great law firms during my career, primarily at Greenberg, where I came in as a junior associate and moved up the ranks during the course of my time there.
What type of legal matters do you generally handle, Brian?
Sure. I handle, business and corporate disputes, but what does that mean? I do a lot of employment-related work, so we're representing companies involved in different aspects of employment. So even though I'm a litigator, one of the goals oftentimes is to avoid litigation, is to try to be a problem solver, to help the client overcome issues. They may, ask for, is this policy that we're doing, is this kosher? Is this something we should be doing? Is there a way to fix this and make it better? And we can look at that. And obviously there's regulations that are constantly changing, depending on different administrations, how they interpret certain issues. And so we're there to guide our clients through that process.
Well, I know that you and I have been talking about doing this show for a while, and you were waiting for something to be done. You just got out of a 3-week trial.
Yes.
Okay. I would be remiss if I didn't ask you to talk with the viewers and listeners about your discrimination case that you handled for a large employer. Can you tell us a little bit about that?
I can.
Okay.
The case itself involved a consumer products company, and the plaintiff in that particular case was alleging disability discrimination or handicap discrimination under the Florida Civil Rights Act. There were also claims for emotional distress, and then there was also a claim for defamation. Jury trials are, by definition, they're tried in front of essentially a random group of individuals, fellow citizens, who are doing their patriotic duty by coming in and serving as jurors, and they're giving up of their time. And it's a different process. You could have a trial in front of a judge, which would be a bench trial. You could have a trial in front of a jury, which is a jury trial. Sometimes you also have, some type of proceedings or arbitration. So that might be a private panel, or it might be a single arbitrator. It really depends on the nature of the case. With respect to the jury trial, jury trials generally take a little bit longer because there's a limited period of time where you can actually present testimony and evidence in front of the jury on a daily basis.
Right.
And then you're obviously working with more people and more people's schedules. So sometimes the amount of time that you have to present in the course of a day may be less when you're dealing with in front of a jury than you might otherwise have if it was just a bench trial. And so our case ended up going 3 weeks. It was a 12-day trial. Ultimately, after a couple of hours, the jury deliberated and gave a verdict completely in our client's favor on all counts.
Well,
So
congratulations.
we were ecstatic, but also very happy for the clients because this is a process, and sometimes litigation tends to extend over a period of time. Most of my cases, most of the things that I do are the types of cases that can be resolved. Some cases I can resolve them within a week of getting a file. In other cases, it can take months. In other cases, it can take years. It partly depends on who you're dealing with, what the issues are that are at stake, how important those issues are, what type of fight is going to be put up by the other side, trying to be reasonable, trying to work together. There's every case and everything that you do, is individualized, and so you have to look at each of the facts on a case-by-case basis.
Sure.
There have definitely been times where we advise clients on how to avoid litigation or to resolve a case early on because it makes sense to do so. Other times, if you feel that you're right and you've got a position and you want to defend that, you have the ability to do that too. We have a system in place that's designed for justice, it's designed for fairness, and that works on both sides of the aisle.
Well, I hear a theme coming from you about trying to get people to avoid litigation. I think that's really important because, number one, litigation is very expensive, and number two, it's so uncertain. It's not as simple as, I just want to try the case. There's a lot at risk there if you take a case to trial, whether it be one of my type of cases or something in your wheelhouse.
Oh, absolutely. And cases come in all different sizes and shapes. So you could have a case over a $300,000 contract, and it could be for purchasing of a home, and there might be defects associated with that, something that's undisclosed. Then you have a situation, for example, the case that I just had, the plaintiff in that case was seeking over $8 million, and so obviously you can mount a defense when, depending on what the allegations are and what the risk and what the exposure is. Just like everything else, it's if you have reasonable minds, you can try to work towards a solution, trying to create win-win situations that might not otherwise be apparent on their face. But sometimes by the time you're getting into litigation, sometimes communication is broken down. It's a hard position. People, are very steadfast in their positions, and you kind of have to navigate through that, ultimately always looking out for what your client's best interests are. Sometimes it may be to fight and go all the way. And for example, if you have cases involving non-compete agreements, either it's going to be enforced or it's not going to be enforced. There's not a lot of wiggle room. There may not necessarily be middle ground. It really just depends on the particular case. When you're dealing with civil cases and the fights are over money, then sometimes it becomes a matter of how much is one side willing to pay versus how much is the other side willing to accept.
You brought up non-compete agreements, Brian, and I know you're involved in those. Are you involved in the drafting of those, or just if it doesn't go well and it needs to be litigated?
The answer is both.
Okay.
And, we will work and help clients and draft non-compete agreements to protect their legitimate business interests. Other times, and I've been on both sides where, there are certain cases where, somebody's trying to enforce a non-compete because they've got a legitimate interest and a former employer or employee may be infringing upon that, trying to take away clients, take away business. That was the company's, so you have those types of situations. But you also have situations where if there's an overreach or if it's too broad, then you can try to work around and try to create a solution or a fix. And so there's still potential negotiation points with respect to those issues. But if you don't assert yourself and put yourself in a position to begin with, you may not be in a position to negotiate at all.
Right.
Conversely, if you're faced with a situation where somebody's asking you to sign one, you probably want to consult a lawyer ahead of time to be like, hey, is this something? What are the ramifications? What can I do if I sign this? Because it's a contract, and once you agree on a contract is a promise between parties. I promise that I won't do X, Y, or Z, and then in return you get something else. So it's promises, and that's what every contract case is. It's a promise somebody made, and somebody's alleging that it was broken.
Non-competes are something that kind of has always fascinated me a little bit because I remember studying them in law school, and our professors told us that the courts frown on non-compete agreements. Is that still the case, that they don't really like them in your experience?
Well, Jeff, on that one, it depends on where you live. And
what about, we're in Florida.
We are
Broward
in Florida.
County, Palm Beach County.
Absolutely. So just to give a global view, if you're in New York or if you're in California, those are two states that are anti-non-competes, and with very limited exceptions, most of them are oftentimes not enforceable, unless you've got very specific targeted issues, and then even then, I know California has general broad policies against them. In a case like Florida, Florida is one of the most pro-employer states in the country, meaning that there's a particular statute that governs these that essentially presumes that in certain circumstances, if you have a non-compete that's 2 years or less for business purposes where you're trying to protect your interests, generally there's a presumption that will be valid, as opposed to if it's over a certain period of time, then it may be presumed to be invalid. And just because the law has presumptions doesn't mean that you can't overcome those presumptions. Sure. But it makes it that much harder. And so there's general guidelines that, when you work in this industry and you have this type of understanding, that certain types of agreements will be enforced and others won't be.
Well, I guess the key word is reasonable. I guess reasonable depends on what state you're in too. In the non-compete agreements that you have drafted, can you give us an example of something that you've drafted that's been deemed reasonable and something you've seen that's been struck down? You don't have to give any names or anything like that, but just to give us an idea where somebody, for example, who is a mailman can't be told that he can't go and sell cell phones or something like that.
Right.
There has to be some type of link, doesn't there?
Sure. I'll give an example of a case that I actually had last year. We represented a sizable real estate company, here in South Florida, but they happen to have a subsidiary that specifically focused on real estate for a specific community. In this case, it was Kings Point up in West Palm Beach and that area. And so in that particular case, they had a former agent who had been on site in the office, who had worked on site with the Kings Point Signature office, who got training, got many leads, years and years and years worth of experience, just because she happened to be able to take advantage of the resources that our client had to offer. In that particular case, the non-compete agreement was upheld. We had an injunction hearing. After a 2-day hearing, the non-compete agreement was upheld. And then, of course, when the other side appealed, the injunction was upheld by the 4th District Court of Appeal. So that's an example of a case where it wasn't limiting it to say you can't sell any real estate anywhere, but it was saying you can't sell in this particular area because this is my specialized community. This is the area where where we have our bread and butter. This is our area. And that particular client was dedicated specifically to that area.
And that makes sense.
Absolutely.
That makes sense.
Absolutely. An example of a non-compete that was ultimately held not enforceable, if you saw it in the news a couple of years ago, there's a time when Jimmy John's said that all of its sandwich makers were held to non-competes, where because Jimmy John's is freaky fast in how they make their sandwiches, that somehow was a patented, or that was a process by which every person who then made sandwiches for Jimmy John wasn't going to be allowed to go work for Subway or go work for another Quiznos or whoever a competitor was. Ultimately, that was challenged, and I believe the news stories kind of indicated that it was not upheld. Now, that's obviously not to say that maybe there might not be other situations, but that's an example of somebody who's making sandwiches can go make sandwiches for any other sandwich shop. That's not necessarily.
So you can go from freaky fast to sandwich artist whenever you want to.
Pronto and Primo's and everything in between.
I've eaten at all of them. So, good stuff. Well, you also, Brian, you're involved in, you mentioned some real estate litigation. What type of cases do you find that you are commonly litigating, if you could?
Sure, I'll give more general examples, but oftentimes you may just have a purchase and sale agreement for a particular piece of property, and then something happens, and either the sale is delayed, it doesn't go forward, then somebody's threatening to say, no, we're going to keep the security deposit, or we want you to make these changes. So you sometimes have those types of issues. You may also have issues where real estate may be involved in a deal, but it might be a family trust agreement, and then you're having a dispute over that, or you've got a limited liability company, and you've got two individuals that are they were once upon a time they were best friends. They think that they're going to be in business together forever and never have any concerns or have any worries, and then you end up with the corporate divorce, where all of a sudden the sides can't agree and they didn't necessarily create an exit plan. What do you do? And those types of situations are difficult to deal with, because you could have resolved many of those issues by upfront having some type of operating agreement that the parties had agreed upon. And sometimes those are difficult questions and people don't want to face them. But by facing them, you can avoid a lot more potential issues on the back end. But as far as real estate transactions themselves, I've been involved in some title insurance cases. We represented the attorney's title insurance fund in a case a few years ago, where a prospective purchaser who ultimately didn't close on a property was trying to claim that the title insurer was somehow responsible and that they lost $35 million in profits associated with the transaction. I will tell you on that one, it took a little bit of time, but we finally got a summary judgment. And that, of course, was also upheld by the second DCA. That happened to be a case that was pending in the Fort Myers area. And then I went up to Lakeland and actually argued the appeal for that.
Oh, that must have been exciting, actually.
That was. That's a whole different process. So I happen to do all parts of litigation. So I will handle a matter pre-litigation itself. So sometimes you've got demands going back and forth between the attorneys. And then in those cases, sometimes you're able to resolve cases pre-suit, so you never actually have to file anything in any courthouse. Then you've got cases that you do file. Some of those cases, you might go to an early mediation, which is when the parties go with an independent, neutral third party who's trying to assist the parties in coming up with a solution that everybody can live with. Otherwise, the case can continue, and then you've got motion practice. So you've got things such as motions to dismiss, motions for summary judgment. If those are denied and the claims survive and the parties can't agree, ultimately you can go to trial. And then, of course, after a trial or after a major ruling in a case that may either dismiss the claims or grant a judgment for somebody, then there's also still an appellate process. So the case may still not be over. And so it's really not over until you get some type of finality, either through the appellate process or somebody gets a judgment against them and then decides to pay. But, 95, 96% of all cases result in some type of settlement. So the parties are negotiating with one another and ultimately come to an agreement that the sides can live with. One side gets a release in return for payment. That's the typical way, and I'm sure that's also how you deal with the personal injury.
Yeah, that's pretty across the board for litigation.
Yeah.
Do you find that most of your litigation is in state court or federal court?
I'm actually fortunate enough to do both, and I do both throughout the state. So, the result of that is in order to get into federal court, either you have to have something which is called subject matter jurisdiction, which is you're suing under a federal statute, and so the court automatically, as a matter of right, would have that. An example of that would be claims that are made under like the Telephone Consumer Protection Act. Just as an example,
Right.
Sometimes people may file a claim under certain of the civil rights statutes, the federal statutes. Then you have the second type of way to get into federal court is something called diversity jurisdiction, which is you have parties that are from different states. So, for example, if you've got a company that's based in Georgia and then a company that's based in Florida, and the Florida company sues the Georgia company in Florida state court, the Georgia company can remove the case to federal court. And there's different nuances and there's different things that go into that.
So what that means essentially is if you file in one jurisdiction and the the plaintiff or whatever party tries to move it to another jurisdiction, you're not thrown out. You can continue on with the case.
Right. The jurisdiction is a huge thing in the law, especially on the civil side. We could talk for hours about jurisdictional type issues, but the crux of it is that jurisdiction is where you're going to ultimately have the case heard. And sometimes, we were talking about state court versus federal court. The process known for taking a case from state court to federal court is called removal. And that's the plaintiff has already chosen the forum of state court, and the defendant would have the opportunity to remove the case if the amount in controversy is significant enough. The current threshold to get into federal court is $75,000 to do that. Otherwise, if you have two companies from Florida, for example, that are fighting over money, that's going to always stay in state court because there is diversity, and so the federal courts would not have jurisdiction over that.
Well, again, we've had a kind of a wheeling, dealing conversation, Brian, and it always is when we get together. But I wanted to end with talking about some of the volunteer and charity work that you do in your spare time. In particular, your work with the Leukemia and Lymphoma Society. I know that that's a cause that's very near and dear to your heart. Absolutely.
So I have the fortune working for a great firm that I do. I try to make it, my personal business to try to give back to the community as I can. And so I'm involved with a number of different bar organizations. One of them is the Broward County Bar Association. I co-chair the professionalism committee. I'm also the president-elect for the federal bar chapter here in Broward. And I serve on a few other various boards from a legal perspective. But in addition to that, what's also near and dear to my heart is Leukemia and Lymphoma Society. I had the honor and privilege of being the Man of the Year for Fort Lauderdale in 2015, and then I nominated you the next year.
You did.
And that was one of those organizations where you're helping a greater purpose than ourselves. We're helping people that we've never met in the idea to hopefully eradicate cancer. And so LLS focuses on blood cancers. And, if you've seen the studies, the treatment and the research that goes into fighting blood cancers is almost universally helpful towards finding cures and finding, other types of medications to hopefully be able to eradicate other types of cancer as well. That if you can solve blood cancers, you would be able to solve the other cancers. And that's what a lot of the scientists and the researchers have said. For me, it was a personal experience. I had lost my mom to a rare form of a lymphoma a few years ago, shortly after my wife and I, Jill, right after we got married. And then earlier this year, in the effort of trying to have the circle go fully around, my daughter was actually a candidate for a Student of the Year recently. And actually just yesterday, we were at Joe DiMaggio giving out a bunch of teddy bears that we had raised.
That's wonderful.
Through the oncology and through the children that were there facing some treatments. And just to put a smile on somebody's face and to know that we're doing what we can to make the world a better place. That's what it's all about. Well,
Again, it was such a rich experience going through that, and I thank you for nominating me for that Man of the Year. And I know that some of you may remember when I was asking everybody for money on that, but it really was worthwhile, and people were so generous. Because everybody's touched by it.
They are, and I've often found that it sometimes is easier to ask people for things that aren't for you than for others. And so in that particular case, it almost became easier over time to just be like, hey, this is what I'm doing. I hope you can help. And, through tremendous support of viewers like you. We are, we're able to come that much closer. And obviously, curing cancer is a great goal. I happen to have been involved with, organizations promoting leadership for young professionals such as Emerge Broward, and then also like the Broward Center for the Performing Arts, and just promoting arts and education in our community. So there's lots of ways to get involved, and I personally believe that it's part of our civic duty and our ability as it's a privilege to be in this profession and to do what we do. And so being able to give back and being able to make a difference and to help people out where we can is just something extra that we do. All lawyers are doing, supposed to do some type of pro bono activities or activities to help the community. And, you do that every day. I try to do that every day, because it does make a difference.
Yeah, it makes it all more worthwhile when you can actually help other people, and through no other reason that you just want to, not that you want anything in return or anything like that. Well, Brian, I've really enjoyed talking with you. I always do. Before we end this, though, I wanted you to kind of tell the listeners who are the type of people that would hire a lawyer like yourself.
Well,
or the type of organizations, individuals.
Well, we represent mid-sized and large-sized companies, and just because we're part of a large law firm doesn't mean that the barrier to entry in that firm is insurmountable.
Right.
It really comes down to what the nature of the dispute is. If you're fighting over, a few $1,000s, we're not going to be the lawyers that are going to be able to serve you in the best way that we can. If you're talking about, sizable amounts of money, let's say $100,000 or more, then we can talk. In certain situations, each case is done on an individualized basis. So there may be cases where you've got $100,000 in dispute, but you may also be able to resolve that quickly for somebody without actually having to file a lawsuit. And you can try to negotiate that and try to work that around. Oftentimes, I deal with companies every day, whether it's, presidents of companies, in-house counsel, and they have questions that they might want to bounce off you, regulatory type questions or questions of, hey, this is our policy. This is what we're doing. Do you think that this is right? Or do you think we should go in a different direction? And, asking those questions up front is going to make such a difference, because you can resolve things and then not necessarily have a problem on the back end, or you did things the right way. So you have a complete defense if somebody tries to say that you did something wrong. So really it just comes down to, if you've got a problem, I talk to people all the time, and there's cases that I'm able to take, cases that I can't take. Some cases I'm conflicted out, and I refer them out to other people who I know would do a good job for a particular client. Really, it just depends on the needs. But if you're uncertain of a particular question, don't be afraid to ask. And you've heard the phrase "penny wise, pound foolish." That example comes up all the time. I had one client who needed an operating agreement for his company. He's like, it's a friend of mine. It's like, it doesn't have to be too formal, but we made it a formalized agreement. And then when he broke up with the other guy who he was involved in business with, he already had a plan in place. So he had the solution. It didn't cost him anything on the back end. All he had to do was say, here's what our agreement says. This is what we're doing. But if you have the situation where you don't have that agreement, you haven't taken the necessary steps, you don't have those protections in place, you could be lost. And then you could be in protracted litigation, because then both sides might become steadfast in how they handle things. So really, it just comes down to, it doesn't hurt to consult. You may not necessarily hire, but if you consult and you have a general understanding of the direction of where this may or may not go, that's the best thing you can do. And I'm there to try to be a quarterback for my clients, trying to get them through the process, explaining things from the start to the finish. But we want to do it in a way that's going to be what their best interests are. And each client may have individualized best interests, but the goal is to figure out what the game plan is, or figure out what your end goal is, and then let's work to try to get you there.
Brian, can you tell everybody how they can get in touch with you if they have any questions?
Absolutely. You can reach me. My email address is kochb@gtlaw.com. And I'm also willing, you see it on my bio, so or if, on my signature block, so you could always reach me. And my cell phone is 954-551-9993. And pretty much as an attorney, we live in a 24/7 cycle. There's always things that are coming up. Luckily, I don't have phones ringing off the hook in the middle of the weekend for hey, somebody got arrested, they need to get out of jail. we're not the lawyers for getting you out of jail. We're the lawyers for keeping you out to begin with, so that the feds don't come after you at all.
That's a perfect segue, because our next show is May 8th. I'm going to have my friend Matthew Konecki, who's a criminal defense attorney. He'll help you get out of jail.
He will.
That's a perfect segue, Brian. You walked right into it.
Perfect.
So I appreciate that.
Well, thank you, Jeff. Thank you so much for hosting and for having me here tonight. It's been a pleasure and a privilege.
Always good to see you, Brian. Thank you, everybody, for watching, listening. Again, May 8th, Matthew Konecki will be talking about criminal defense, and I'm really looking forward to that one. There might be some wrestling puns in there, here and there. Matt and I are big wrestling geeks. Take care, everyone. Have a good night.